All right, we're looking at confidential sources. We are going to ask a couple of questions and we'll watch a video clip in a minute. But first, the first question we ask is, what is a confidential source? It's a media source that is not named publicly. And this became popular after the 1970s, and there was a famous case which we will talk about. But it's a source that maybe people will say a source close to the administration, or a source within the circle of knowledge, or something like that, where the name won't be actually made, but the person will be they will be listed as a source. The most famous confidential source was Deep Throat, who was a source. That was the name of the source who exposed Watergate. Watergate was a situation where President Richard Nixon had allowed some people to break into a hotel, and there was all kinds of illegality and wrongdoing and a huge slush fund. And the main thing that concerned Nixon was that he covered it up and said it did not actually happen. Now, here we have two reporters, or people, actors playing reporters. That is Dustin Hoffman in the picture here, and the actual reporters who were involved with this were Woodward and Bernstein, and they wrote a book called All the President's Men. Now, you can see here the actual movie, which you can still watch, and we can actually watch a clip from that, and you can see that they are meeting, or one of the reporters is meeting with the Deep Throat, the confidential source who doesn't want his name released, and they are promising him confidentiality, and he's very concerned about his own safety.
You can trust me, you know that. Come on. Can you tell me what you know? You tell me what you know. Hunt worked for Colson at the White House. Hunt was investigating Kennedy and Chappaquiddick. That should tell you a lot. What else? We're beginning to hear a lot about a lawyer in Crete named Gordon Liddy. Gordon Liddy, who was fired by Mitchell because he wouldn't talk to the FBI. You'll hear more. Will he talk? I was at a party once, and Liddy put his hand over a candle, and he kept it there. He kept it right in the flame until its flash was burned. Somebody said, "What's the trick?" And Liddy said, "The trick is not minding." The story is dry. All we got are pieces. We can't seem to figure out what the puzzle is supposed to look like. John Mitchell resigns as the head of Crete and says that he wants to spend more time with his family. It sounds like bullshit. We don't exactly believe that. Oh, but it's touching. Forget the myths the media's created about the White House. The truth is, these are not very bright guys, and things got out of hand. Hunt's come in from the cold. Supposedly he's got a lawyer with $25,000 in a brown paper bag. Follow the money. What do you mean? Where? Well, I can't tell you that. But you could tell me that. No, I have to do this my way. You tell me what you know, and I'll confirm. I'll keep you in the right direction if I can, but that's all. Just follow the money.
Okay, now the reporters kept the confidential source's name a secret until the confidential source's death. So that was how, about 25 years later, so that was how much they believed in the confidential source idea. The use of it since then has expanded. People have used it, or did use it quite a bit. It's not used as much now, but you still see it a lot. And but they showed that the confidential source, the anonymous source, can actually be a source for good and could keep democracy running. And so it helped with the marketplace of ideas. And basically, it made confidential sources popular. I was very young when this happened. I remember watching it unfold on television, and I was one of the things that made me interested in going into communication. A couple of years ago, interesting story, I was finally able to meet Bernstein and talk with him and ask some questions, and it was a very exciting time. So that was the case that made confidential sources popular. Now, I said we would look at some questions. Why use confidential sources? Well, the source may be the only one who knows the information. They may be somebody within a administration, within a government office, within a illegal enterprise, and so they may be the only way to get the information. Now, why are they anonymous? They fear reprisals. They fear something might happen to them. In the case of Watergate, the person in charge felt that he would lose his job, maybe even his life, if he talked about it. Now, the downside is that there is some lack of credibility. The source may be lying, and there's no way to test the authenticity of the source other than taking the reporter at their word. So that's very important that the reporter have a lot of credibility before using a confidential source. Now, a reporter can be jailed in some states for not revealing a source. If a judge asks you to come into a court and reveal a source, if you do not and you're in a state that doesn't allow that, you could go to jail for, usually it can be over 2 years, and that is for contempt of court if you don't follow a judge's orders in some of those states. So this can be a very serious offense. A judge basically can charge you with contempt of court, and you don't even have to be a journalist. In fact, if you are writing for a blog, and there have been cases where bloggers have been told they need to give their sources, that can happen as well. And actually, the idea that bloggers can be considered journalists has helped in a number of cases. It's a good thing to know. But it's state laws which protect reporters that actually protect the reporters. It's not federal laws. And the state laws are called shield laws. Now, you might be wondering whether Illinois has a shield law. We're going to talk about that. I'm going to tease you about that. We will talk about that. But first, we're going to talk about an important case that has helped us understand this. It was Branzburg versus Hayes in 1972. And the Supreme Court looked at 3 cases on confidential sources. Branzburg versus Hayes was one of them. It was the main story, and it was by Paul Branzburg. He was a young reporter for the Courier Journal. Now, he did a story on drug dealing, and he used confidential sources. 2 of those confidential sources were hashish dealers in Louisville, Kentucky. Not actually that far from where we are here in Illinois. And hashish is a powerful form of marijuana, a derivative of that. And so this was shocking to the people in Louisville. Several others, confidential sources, were users. One was 14 years old. So this was a very impactful story. Now, the prosecutor in Louisville, Kentucky was embarrassed. He is supposed to be prosecuting crimes. Here is a reporter showing that he wasn't doing his job. So the prosecutor created a grand jury. He demanded that Branzburg reveal who his sources were. And there were state shield laws. And here we have a picture of where where it is, but an idea of where that is. Now, Branzburg said no to the grand jury in revealing his sources. He said, I am not going to go in front of the grand jury. He expected to go to jail. He was a young man who was very passionate about his beliefs in the First Amendment. He actually brought a packed suitcase to court, and the judge delayed sentencing. So he was expecting to go to court. He had actually brought money with him so that he could rent a television in the county jail, and he was almost disappointed when the judge delayed sentencing. It then went to the Supreme Court, and the Supreme Court looked at several cases. The Supreme Court ruled that there is no absolute privilege. A reporter can't, across the board, say, I cannot be free from going to a grand jury and testifying. However, they did say something that is very important. They said that courts must decide whether to allow confidentiality on a case-by-case basis. And that meant that it wasn't up to the Supreme Court. It was up to the states to make those rules. So that became very important. And different states, sure enough, began to make different rules about that. Some actually didn't have rules, and it was decided by specific court cases. The result of the Brandsburg case, I'll tell you what happened, even though we found the part about what happened in regard to the law. Interestingly enough, Brandsburg left the state before the Supreme Court ruling came down. And this was important for him. And the prosecutor didn't pursue charges. And I believe Brandsburg had gotten some advice and said, if you leave the state, when, regardless of what happens, the prosecutor will not be able to charge you unless you're in the state, because he doesn't have that. That's the limit of his power. So Brandsburg, in the end, neither revealed sources or went to jail. Now that's the personal story. From this, we have some Brandsburg court criteria in regard to confidential sources. One, the reporter's information was clearly relevant. So relevance is important. Number two, the information could not be obtained elsewhere. He used confidential sources, and there was no other way he could have gotten the information. So it helped the marketplace of ideas. Number three, the government had a compelling interest in the information. It was important for the government to learn about the information so that people would understand what was happening in the community. So three criteria. So the result was a generally understood qualified privilege for journalists. In other words, they said there was no absolute privilege, but they didn't say there wasn't any privilege. So journalists now do have a qualified privilege, but it varies from state to state. Illinois does have a limited shield law for reporters, and some court cases have affirmed that. So if you're in Illinois, actually, you're better off than many other states. A long time ago when I was a journalist in Missouri, I remember thinking that Illinois had some great shield laws. Now, their wiretap laws are not so great. If you're doing a telephone interview, you have to get people's permission, and if you're videotaping, there's a lot of strict rules for sound. But as far as shield laws and confidential sources, Illinois reporters are better off than many other states. Now, we were talking earlier about questions. So the question now is, do bloggers have reporters' privilege? Now, I might, if we were in the class, ask people to defend why or why not. And this is interesting. I remember years ago when bloggers first emerged, people were wondering, what were they? Were they reporters? They couldn't be reporters. People thought because they hadn't gone to school, they weren't actually going to places. So this was a big debate. And so the real question is, are bloggers journalists? And that is another question that is interesting to discuss, but it varies state by state. Now, in California, Illinois, New Hampshire, New Jersey, and Oregon, there have been cases that looked at this and decisions have been made. In other places, bloggers might not know what exactly they are going to face. Some courts have said, yes, bloggers are journalists, and other courts have said no, and there is no Supreme Court decision. So what are the rules that you go on? Well, here are a couple separate cases. In California, an online magazine leaked Apple products. What we mean there is they got some advance information and leaked information about an iPhone. Now, Apple tried to get their sources, their confidential sources. Ultimately, the judge in California said there's no difference between online and offline magazines. They have the same protection. That is pretty strong. That is saying that bloggers have the same rights than if you were publishing a national magazine. Very important case, but that's only for California. New Hampshire, there was a site that was monitoring mortgage rates and listing those and comparing sites so that people could go in and see what mortgage rates were being used, and they could shop and guess the best rates. Well, some people didn't like that because the people who had the mortgage rates wanted to be able to have a higher mortgage rate without the consumers knowing. However, the courts in New Hampshire said that site was protected. It was something that the public should know. You wouldn't think of that as journalism, yet it got that shield law protection. Then we have Illinois. Apple Computers, once again, is fiercely protective of its information. Apple Computers subpoenaed a blogger who had pictures of an unreleased iPhone. Wouldn't you love to have pictures of the next unreleased iPhone? You could find out what you are going to be spending or overspending your money on. So this blogger had pictures of the iPhone, released the information. A court said, and this was in Illinois, the Illinois court said the blogger had shield law protection. Now, this wasn't about government information. This was just information about a cell phone. Still, that person had shield law protection in Illinois. So that is good news if you're a reporter in Illinois. Actually, it's good news if you do any blogging at all, to realize that you do have some protections similar to or very similar to what online magazines may have. Now, New Jersey and Oregon cases also came up. They said there is no privilege for bloggers. So if you wanted to be a blogger and you had the choice of being in New Jersey, Oregon, or Illinois, you would definitely choose Illinois.